Good afternoon. You're welcome to the Law, Finance and Economic Policy Talk Show. I bring you greetings from Lagos, Nigeria. Today we're going to be talking about something very interesting. I have my laptop right here, so permit me if you see me looking down. It's just so I don't miss out on any salient points. So we'll be talking about the Securities and Exchange Commission's rules on issuance, offering platforms, and custody of digital assets. This was released a month ago, thereabouts, May 11 of 2022, but it's still very interesting, and we're just going to be, dissecting it. So let's get right into it. Essentially, what SEC's regulation tries to do is to govern digital assets. When I say digital assets, what do I mean? It's what we all typically know, like cryptocurrency, Bitcoin, and the likes. Now, let's go back a little in time, Nigeria's history when it comes to virtual assets, cryptocurrency, and digital assets, essentially. So we know that sometime in about 2017, the Central Bank of Nigeria released a statement speaking about how virtual currencies are not a legal tender and warning the general public to stay away. They also mentioned things about how it could be used to finance terrorism and just essentially a stern warning. But then in about 2020, 2021, they released a harsher statement essentially banning banks from operating accounts for platforms or companies that offer any form of cryptocurrency, which in a sense leads people to say that cryptocurrencies have been banned in Nigeria. Banned in the sense that you can't really open a bank account or move funds through traditional Nigerian institutions when it has to do with virtual assets and cryptocurrency. So now SEC permits me, being the Securities and Exchange Commission of Nigeria, at some time last year mentioned how it will be releasing regulations that will protect investors that invest in such assets. So this is essentially what this regulation seeks to do, and we'll just go right into to see what it governs and what it offers. Now, there's one thing that I want us to keep in mind as we go through this regulation is the difference between digital assets and virtual assets. That sounds a bit confusing. Is there really a difference? Now, in the natural everyday business or business sense, there's no difference. Digital assets and virtual assets are what we generally call cryptocurrency, or just assets that are backed in a virtual asset, through some form of DLT or blockchain technology. Now, what SEC has done is that it has divided the meaning. Now, when it comes to digital assets, it says digital assets means a digital token that represents assets such as a debt or equity claim on the issuer. When I look at this, I just think about asset tokenization. Many of us are familiar with initial coin offerings and the like. So what this just means is that you take something that is like a debt or an equity, that is, for example, shares in a company or debts from a company, and then you tokenize it, you make it digital. That's essentially what they've defined digital assets as. Now, as virtual assets they've described as a digital representation of value that can be transferred, digitally traded, and can be used for payments or investment purposes. Now, when you think of this, you just think about cryptocurrency. So what they've done is to divide cryptocurrency on one end and regulate that, and then they've also decided to regulate when people take natural securities or debt and tokenize it. So just keep that in your mind as we go through this and as you also read the regulation for yourself. Now, we'll start with how they regulate digital assets. So when it comes to digital assets, there are basically three people that they regulate. They regulate the issuer. That's the person that is seeking to raise those funds, seeking to tokenize the debt or the security. Now, they also regulate digital assets platform provider, and lastly, they seek to regulate custodians. We'll get right into that. Now, for the issuer, before you issue any form of digital assets, you have to submit an assessment form and a white paper to the Securities and Exchange Commission. What the white paper tells us is essentially, what are you raising this money for? What is it meant to do? What is the soft cap and the hard cap? The soft cap being the minimum amount that is required to fulfill that project, and the hard cap being maybe your ideal amount or the maximum amount that is required. We want to understand who your founders are. We want to understand how the business works. We want to understand what the price is. What are you offering people in return? What are timelines? Just essentially getting to know the product as a whole. And then SEC now goes on to review this. There's about a 30-day timeline within which they review this to approve or to disapprove it. Now, when they come back, they can come back with two things. They can just approve it, and on the other hand, they can say, three things rather. They can reject it or they can approve it. They can approve it and say that this seems like a security. That is, this seems like the average securities that on a normal day SEC would, requires to be registered. For example, shares. So when this happens, you now still have to register that product separately. So first of all, you seek SEC's permission to go to the market, and then you still also seek SEC permission to register that what is qualified as a securities. There are limits to what you can raise. You can't raise more than 10 billion naira. And then it's not just that. You can't raise more than 10 billion naira, but at the same time, you can't raise more than 20 times shareholders' funds that you already have. And there's also investment limits. And the investment limits, well, when it comes to qualified investors and high net worth individuals, there's no investment limit. But when it comes to normal everyday retail investors, it's limited to 200,000 naira per issuer and not more than 2 million naira in every given year. So that's just to protect a retail investor, because retail investors are not meant to really understand, are not taken to understand the capital market or the risks that are associated with investing in the capital market. Hence that restriction, especially when it now comes to digital assets that are qualified as not being as safe. Another thing I really wanted to note is that if you're aware with when SEC decided to regulate crowdfunding portals, you might have a mix in your mind, because some of us thought that crowdfunding portals could also, sort of tokenize assets, but no, they can't. The difference here is that crowdfunding portals raise pool of funds from many investors, but they're raising sort of cash. The cash can be for equity, but the cash can be for debt. But when it comes to digital assets, you're tokenizing an asset. You're turning it from money, turning debt to equity, and then you're making it into form of a token. And then what this SEC has done here is that it has noted that if something should ideally qualify under the crowdfunding regulations, then there will be an exemption here. They wouldn't have to register here as well. They would just go to the crowdfunding regulations. If you want us to look at the crowdfunding regulations, even though it was from early last year or late 2020, we can still do that. Do let me know in the comments if that's something that you'd be interested in and would go for it. Now, let's talk about the digital assets offering platform, aka the DOPs, or like DOPE if you like to call that. So that's just an electronic platform. So when you have an issuer who's interested, they have to go through an electronic platform. It's this platform that would, the members of the public be able to invest through, and then we see that, and then invest through that platform. So they also have to be registered. They have to be registered with Securities and Exchange Commission as a capital markets operator. And what is interesting here is the financial cap that they have. They need to have a minimum paid up capital of 500 million. This needs to be in things like bank balances, fixed investments in quoted securities. You just need to show that you're financially solid. And then you also need to get a fidelity bond of 25% of that 500 million. So it's a huge financial requirements. They don't want people that are jokers in the industry at all. So what they just have to do is that they have range of obligations. They have obligations to investors, they have obligations to SEC. And what they essentially have to do is that even though SEC has already approved an issuance or an issuer, they come through a second layer of the platform. The platform has to go through the white paper, make sure that everything is in check, make sure that there's no falsified information, make sure that investors are aware. They also need to make sure that they have a warning on their site, which lets investors know that your investment is not protected by any investment fund. If you lose your money, you lose your money. Just essentially making sure that investors are aware. And then they also have the duty of opening trust accounts with different banks, and these trust accounts enter into an escrow agreement with the issuers, where the money goes into that trust account, but you don't release it to the issuing company yet. You wait until they are done with raising, and if they don't raise up to the minimum amount that is required for that project, it is not released to them. And also, if they find out later on that there's any form of misleading information or just things that of that nature, then they will not grant the release of the funds to that issuer. Now, SEC also permits the platform to also add other condition precedents to the release of that sum. So SEC actually wants you to be very strict in your monitoring to ensure that investors' money are protected. Just some other things that we also want to note is that they also have duties when it comes to token and ensuring that an individual's digital assets and information and all of that is protected. We know essentially would know how that works, especially when we think about from a data protection level. So they have to have established secured stored medium to store those virtual assets. They need to establish controls for maintaining accurate records, so that there's a detailed record of transfers between one investor to another, one token holder to another. Now, this is where custody of virtual assets and digital assets comes into place. Now, what I want to say here is that SEC is also, SEC has traditional custodians, and what custodians essentially do is that they hold your assets for you. But when we think about digital assets, especially when it comes to tokenization, I tried to do some research on people that perform this function, and I came across BitGo, and I find what they do also very interesting. So now let's talk about custody. So the law says that you can appoint a digital assets custodian registered with SEC for custody of the token holders, or the platform can carry on this function by itself. But if the platform wants to carry out this function by itself, then what it has to do is that it still has to register with SEC and fulfill the conditions that a custodian would have had to fulfill in the first place. So that's something very important to mention. Now, like we said, custodians are traditionally service providers who hold your assets on behalf of you for a fee. But now what we have here is, we're not looking at assets in the traditional sense, the safekeeping of assets in the traditional sense. What we're looking at is the storage of cryptographic keys. So those are the keys that grant you access to your token. So yes, that was also a bit confusing for me, but I've come to understand it sort of as just protection of the keys, protection of the access to your tokens. So that's what they do. They keep that information secured. They custody those information in their own deposits, and for a fee, I would believe. Now, the rule doesn't say who bears this fee, whether it's the issuer, whether it's a platform, or whether it's a consumer. I believe that would be something that will be determined by these players. So yes, that's also very interesting. Beyond this, what the custodians just have to do is to ensure security of your information, ensure your data is kept confidential, ensure that all the fees that have been leveled on you are fair and equitable, and also just generally take care of the investor's interest. So you can see that the investor's interest is a key concern for SEC. So essentially, I think we've done a good job at summarizing the regulation of the digital assets angle. Remember what I said, the digital assets has to do with asset tokenization. Now we'll be going on into the virtual asset service providers. So let's take a quick break for me to drink some water, for you to also drink some water, and just also assess the information that we have. Start commenting on your thoughts, start commenting on things that you also have like a wider understanding on, and I'll be back in a second. Welcome back. I'm well refreshed and hydrated, and let's get into the virtual asset service provider angle. So like we said, when it comes to virtual assets, we're just thinking about your typical cryptocurrencies. And now what SEC has also done is that it has brought everybody that you can think about that will provide a service when it comes to virtual assets, cryptocurrencies, and it has brought them under its regulation. So it notes that a virtual asset service provider would include anybody that facilitates, I'm just going to read it, exchange between virtual assets and fiat currencies meaning your average naira, dollar, pounds, exchange between one or more forms of virtual assets, transfer of virtual assets, safekeeping and administration of virtual assets. When we think about that, we think about the custodians who are, the digital assets custodians I already mentioned. They can also provide this function. Anybody that participates in the provision of financial services related to an issuer's offer. So even if you participate in anything that has to do with an issuer's offer, providing any form of financial service, you would also fall under and also be a virtual asset service provider. It just says foreigners or non-resident operators that are targeting Nigeria. So you don't even have to be registered in Nigeria to be caught by these regulations. You just have to target Nigerians through emails, through any form of publicity. As long as you're targeting Nigerian market, you're expected to come and register under this particular section. So if you're providing services such as reception, transmission, execution of orders on behalf of other persons, dealers on own accounts, portfolio management, investment advice, custodian or nominee services. So you would even be covered under this if you're a portfolio manager that is advising your clients on assets such as on digital and virtual assets. So you'll be covered. You'll be covered if you're a nominee company that normally provides nominee services to investors who don't typically want their image out there. If you're providing any form of nominee service that has to do with a virtual asset, you'll be covered under this, and you're expected to register with SEC. I have some reservations with this because it's how do you enforce compliance? How do you make sure that people actually come and register? What's my incentive as a foreigner to register, and how do you levy sanctions on me where I don't? Because this is really broad. It would mean that if somebody somewhere far away is providing nominee services for a Nigerian, they'll be targeted under this. Or if I'm a portfolio manager in a foreign country and I'm advising a Nigerian, or just anything, it's just I'll be covered by this. So it's very broad. I think it would have been ideal if we just maybe limited it to just the platform and maybe the issuers themselves. Then that would have been ideal, because what you have now is that people that, let's get it right, we all know that all these platforms are still thriving. All that happened is that when CBN came up with his mandates to the banks, they moved their operations offshore outside Nigeria, but they're still targeting the Nigerian market. How do you stop people from targeting the Nigerian market? I think that's a major issue with this regulation. It's just, what is my incentive, especially because the capital requirements are really high. So won't people want to remain in more friendly climes where the regulation is more relaxed? So that's just something for us to think about. I'd like your thoughts in the comment section as per usual. So let's just try and round this up because the video is already getting long. So now, I guess the incentive is that for you to just be a virtual asset service provider, there's really no capital requirement, but you just need to show SEC that you have the resources financially, infrastructurally. Then you need to give some undertakings that you comply with their rules and all that, amongst other things that you need to show them. But there's no capital requirement, unlike for the digital assets platform. But if you're a virtual assets platform, which is what we're going to next, there's also a 500 million capital requirements, just as the digital assets platform have. So now for the virtual assets platform, what you do is just like the digital asset platform, you're a platform where people can trade in virtual assets. I think that one person should be able to perform both functions. I mean, it would be ideal for you to actually apply for both licenses. That just allows you to have a wider range of the market if that's what you want to do. Now, so for the digital assets exchange called the DAX, so you also need to have that 500 million capital. So what you do is facilitate trade between individuals. You advertise. You have different virtual assets on your platform, and people can buy that as well. So that's what that does. Essentially, just the different platforms that we can just go on and buy crypto. So things like Binance. That's essentially what this would be doing. Binance, Luno, and the likes. So obviously they have some requirements or some obligations that they have to fulfill. They need to submit periodic, I believe monthly or so, return records to SEC, and that's just a summary of it. So we'll just keep it at that. Now, almost on the final notes before I go into some conclusion, is that one bump that SEC just drops at the end of the regulation is that it will charge a fee on every transaction that is carried out on the platform, on the digital asset, on the virtual assets platform, and that is almost ridiculous. Like, it's like SEC really wanted to secure its bag, secure its earnings, secure its own earnings when it comes to this. And that's another thing when I speak about incentives. So as opposed to SEC doing maybe like an annual fee, what they've done is that on each transaction, they will earn a fee. Well, if that works, that will be a lot of income for them, but I don't really see how this would work. Now, on a conclusionary basis, I think that another thing that we'd have to wait for is to see how CBN reacts to this. What is going to be the CBN stand? SEC has come from a securities regulator perspective to say that these things are sort of securities, so I'm going to regulate them. But what about CBN? What is CBN as the primary financial regulator? What is his take going to be? Because as long as he has in place that restrictions on banks, how effective can we actually have this regulator? When we have one regulator in Nigeria that is saying that something shouldn't be allowed, and then you have another regulator that is regulating it and having fees on it. So I foresee that within the coming months we'll see some amendments, or we'll see some form of, you know, harmony between both regulators, and it'll just be interesting to see what happens. And I'll be here to also give you the first hand just when it comes out. I think that's pretty much it. Let's just end it on this note so it doesn't get too long. Please let me know what your thoughts are. Let me know what your comments are. Just let me know what your own interpretations of some of the provisions of the regulations are, and what you think their implications are. Thank you so much, and see you in the next video. Bye.